Hi, I'm attorney Louise Fiore.
And I'm attorney Dina Huber.
And welcome to Law Hub. All right, so today we're going to be discussing an important topic that deals with family law and immigration law. And in this topic, a lot of times what a family law attorney would advise someone to do is the exact opposite of what an immigration attorney would advise you to do. And that is prenups prior to entering into the marriage if you're going to be utilizing the marriage to be able to get your paperwork through immigration.
So, Louisa, you're talking about if somebody is going to be sponsoring their future spouse and whether or not they should enter into a prenuptial agreement.
They can enter into a prenuptial agreement from the immigration side, but it's how they enter.
Okay. Can you elaborate on that?
So I guess, let's start with you. So when you're screening, when someone comes to you and they're about to enter into the marriage, and let's say the wife, the fiance who's going to be the wife, has multiple properties in the United States, and also has multiple properties. Let's say that she's from Italy. She has multiple properties in her country of origin.
Okay.
The future husband has a business here and he has one property here. When you're screening for that, would you not most of the time advise them that what you're coming into the marriage stays there and what? Okay.
So generally speaking, the motivations for wanting to have a prenuptial agreement are people wanting to define what their premarital assets were, and also wanting to have a clear agreement that in the event that they were to divorce in the future, what their rights would be with respect to those premarital assets and assets acquired during the marriage. So in a case like that, and often in cases where the parties have children before the marriage, they'll want to have a prenuptial agreement to address those issues. So if a client comes to me and there's also an immigration element, oftentimes I will call you and consult with
Yes.
you about what to do about it. But it's really important because we want to make sure that nothing in the prenup undermines the legitimacy of the marriage or, would give rise to the suspicion that the marriage is not a legitimate marriage because the parties have a prenuptial agreement.
So that's kind of where we enter into this really interesting land, right? Because when we do have these conversations, a lot of times you've said to me, well, have them, if they have separate bank accounts, have them keep their separate bank accounts, right, and they can do one joint bank account for entering into the marriage, right? Well, some adjudicators in immigration are going to look that those separate bank accounts remain separate as a negative for the immigration side. The other issue is, let's go back to my hypothetical. You have the husband who's here, and let's say that he's petitioning for the Italian wife, and he has a property here, and she's moving into this property, and it's solely under his name. And now you have a prenup that says that property is going to remain his property. Yeah. That's something else the adjudicator is going to look at and say, wait, you already have one foot out the door. You're not, she's moving in there, but you're already making it temporary. You're already planning on a divorce.
Right. Which is interesting because nowadays, if you look at the divorce rates in the United States, for first-time marriages, they're above 50%. So anyone getting married, whether they're a recent immigrant or not, or an immigrant in progress rather, they have reasons to want to protect their financial security if they have premarital assets, and to also have a clear plan for how things will be handled in the event that they do get divorced, which is a very real fact, immigrant or not. I've done many prenuptial agreements that have an immigration element, and one of the things that I like to do is include certain language in the agreement as to why the parties want a prenuptial agreement to try to address that. And you and I have done this together, which states that, for example, if the parties had children from either from other relationships before they got married, or if they have significant business assets that they want to protect, so that way it allows them to have a prenuptial agreement to protect their interests without it undermining the I don't want to say legitimacy of the marriage. What's the word that we're looking
bona fide.
for?
If the marriage is a bona fide marriage,
correct,
which is what an immigration adjudicator is looking at.
Right.
And bona fide marriage is not properly defined, in my opinion, even within the regulations of immigration law, because how do you define a bona fide marriage? To your point, if we want to keep certain things separate for my child from a previous relationship, that I want to be able to have them have the rights to the home because that's their childhood home. Right. Those things are legitimate, absolutely, but they can very well undermine if not properly explained, undermine the immigration process. When
So what do you think of that as a potential solution, is to include language that says that the reason why they're doing it is they have certain business interests, sometimes they have business partners, there's children. You know, it's almost like an unnecessary step in the interest of a prenup, but it doesn't hurt the prenuptial agreement to have that language, and it supports their immigration case.
I think that for those special cases where you have the immigration component with the family law component, you almost always have to have a purpose. And we've done this before, where you have a purpose for every clause.
Right.
You have a purpose for, let's go back to the home. You have a purpose of why the home is being excluded just to one spouse. You have a purpose of why the business is being excluded. You may even, and we've gotten into this, where, you know, the marital couple is also starting their own business, and they want to be 50% owners, but they want their shares to go to a sister or to go to children. You want to have that purpose. You want to have that explained, like, why is that happening?
What are their intentions? And I think that's the other important part. You know, prenuptial agreement doesn't just deal with premarital assets, it deals with assets and income that are acquired during the marriage. So we can address those, you know, in preparing a prenuptial agreement in this type of case. We can address those areas very carefully, so that way we can demonstrate for immigration purposes that this is a very real marriage, that they're going to have all the elements of a real marriage, which include the sharing of almost that financial risk. Saying that, okay, we're going to have a home together, this is how we're going to pay for that home. And I think that as long as it is consistent kind of with what the practices are of like the general public, meaning it doesn't look like a total one-sided prenuptial agreement, I think that we can make it very strong and make it very specific for the parties and for their specific circumstances. And you know, so we would look at things such as assets acquired during the marriage, income during the marriage that pays off assets. For example, if they purchase a home together and their incomes are contributing to pay down a mortgage, what happens to that? We talk about alimony. We talk about all these other things, so that if immigration is looking at this document carefully and saying, oh, is this a bona fide marriage? Is this a real marriage where they intend to actually stay together? Because I think that's what immigration is looking at. Do these people intend to actually stay together as husband and wife? That we have all of the language in that agreement that supports that.
You made a good point that I kind of want to go back to, the whole alimony aspect, right? So alimony, I always find it fascinating on immigration law, and you and I have talked about this, because in family law, it's pretty standard, right? You kind of do the alimony based on years that you've been in the marriage. So if you've been, the longer you're in the marriage, the more entitled to alimony you're going to be. What makes interesting to me is that can actually backfire on the immigration side, right? Because on the immigration side, the 3-year rule is a lot more complex, and we can go into that in another video, but there's that concept that you should be married for 3 years. So it's almost like, depending on how you word that alimony clause on the 3-year aspect, it can very well backfire on the immigration side, because they're saying, well, you basically trapped him or her, the USC, the United States citizen, into staying married with you so you can get your citizenship. Because if he leaves, he's going to have to pay money and so on.
Right, and this is why it's very important that parties in this situation really have their family law attorney and their immigration attorney working together, and that we can sit down together and craft just the right language to make sure that we're meeting all their needs, meeting their needs in terms of a prenuptial agreement and meeting their needs for immigration purposes.
Exactly. Well, that's all for today, and stay tuned for other videos on topics in Law Hack.
See you next time.